It's a Sunday morning here in Broadford in County Kildare, and I'm at home, and I was just thinking there. I wrote an article yesterday and I published it on my website, employmentrightsireland.com, and it's about the Protected Disclosures Act of 2014. And it's probably worth a look, regardless of whether you're an employer or an employee. The Protected Disclosures Act 2014 came in with pretty strong powers in it, pretty strong remedies for employees who make what's called a protected disclosure. And initially there was a certain amount of fear and trepidation, I suppose, amongst solicitors for employers and indeed amongst employers. But it was hard to know when the legislation first came into effect what the actual effect in practice would be. But recently, in September 2016, it's begun to become clearer what the situation might be and the consequences for employers. Basically, the Protected Disclosures Act of 2014 can award or can see an award of up to 5 years' salary being awarded to an employee who has been unfairly dismissed for making a protected disclosure. So that's one remedy, and it's a pretty strong one. 5 years' salary. Like 5 years' salary to any business is a significant amount of money if it was awarded against them. Now, that's not to say that it will be awarded, but that's what's on the statute books, and your normal situation for an unfair dismissal is a maximum of 2 years' salary. So 5 years' salary is clearly very, very serious. But there's another aspect to it, and that is that there's a provision in the Act which allows an employee to get what's called an interim relief order. And this allows the employee to go to the circuit court and get what's effectively an injunction preventing his or her dismissal for making a protected disclosure. The employee, if he's dismissed, has 21 days to go to the circuit court, and if he can show substantial grounds for contending that the dismissal is related to or connected to a protected disclosure that he's made, then the court is likely to give him an injunction, and the effect of that is as follows. The employer can be ordered to re-engage or reinstate the employee or pay full salary until the hearing of the employee's complaint to the Workplace Relations Commission for unfair dismissal. So let's say you're an employer or indeed an employee and there's a dismissal and it's claimed that it's for protected disclosure. Then the employee can end up going to court, to the circuit court, getting an injunction, getting full pay until the hearing of the action, which could be any time from 12 weeks to 20 weeks after the dismissal. That hearing would be at the Workplace Relations Commission. It would be for unfair dismissal. And so up to that time, the court can award, if the employee is successful, the court can award the interim relief order, essentially an injunction. So again, that's a fairly tough sanction on the employer and something that he's got to be very, very careful about, because clearly having to pay somebody's salary until the hearing of their unfair dismissal claim for anything up to perhaps maybe, anything between 12 and 20 weeks, that's bad enough. But if you then go along to the Workplace Relations Commission and as an employer, if you lose your case and if the employee wins the case, the potential sanction, as I said, is up to 5 years salary. Now, up to relatively recently, up to September 2016, there was no cases brought or no applications brought for interim relief. However, in September of 2016, the first such case came before the courts and the interim relief order was granted. And this was a case involving two people who had been made redundant from their employment with the Lifeline Ambulance Services. Lifeline Ambulance Services, I think, is owned by David Hall, the mortgage campaigner. You'd hear him on the radio and see him on TV a lot, but he made these two people redundant. They claimed that in fact it was an unfair dismissal because they made protected disclosures, and they were successful in getting an interim relief order from the Circuit Court. Now, the Circuit Court, I understand, ordered that they be reinstated or re-engaged, but in fact the employees didn't want to go back prior to the hearing of their claim with the WRC for unfair dismissal. So the court then ordered that they be paid full pay until the hearing of the case. Shortly after that case, that Lifeline ambulance case, there was another case involving a lady who was an office manager, I think, in Cork. She was dismissed. Again, she made a claim for unfair dismissal based on the fact that she had made a protected disclosure. She had made some complaints about the health and safety in the workplace, and again the court decided, I think it was Cork Circuit Court, gave her the interim relief order, which essentially meant again that she was to be paid full salary until the hearing of the WRC claim for unfair dismissal. And then there was another case involving a man, Mr. Philpott in Cork, who brought a claim. He had a 5-year contract in his job. However, he had interpersonal difficulties with other members of staff. He was going to be dismissed. He was told he was going to be dismissed. He didn't have 12 months service, and consequently he wouldn't have had the benefit of unfair dismissal legislation. He brought a claim for unfair dismissal, though, based on the Protected Disclosures Act of 2014, claiming that the reason that he was dismissed or going to be dismissed was because he made a protected disclosure. Now, in this particular case, the court found that that was not the case. The probative burden, the burden of proof that's required, is that the employee must show that he was wholly or mainly dismissed for making a protected disclosure, and he must then show in court that he has substantial grounds for making such a claim. If that's the case, then the court is likely to give the injunction, the interim relief order, giving him either full salary or reinstatement or re-engagement until the hearing of his claim or her claim for unfair dismissal at the Workplace Relations Commission. So that's the Protected Disclosures Act 2014. As I said at the outset of the video, there was a certain element of, not actually knowing exactly how it was going to go, and until people obviously bring claims to court or bring claims to the Workplace Relations Commission under the legislation, it's hard to know how it's going to go. But now, clearly, going to the Circuit Court and getting an order for interim relief, getting what's effectively an injunction from the Circuit Court, is a far cheaper option for an employee than going to, for example, the High Court, where he would have had to go before. And as I say, the sanction then is fairly eye-watering. 5-year salary for unfair dismissal because of making a protected disclosure. That's something that any employer is going to want to avoid. I hope you find the video useful. If you do, you might give it a thumbs up down below. Perhaps you might be interested in subscribing to my YouTube channel. And if you're already a subscriber, let me know below in the comments what you'd like me to make videos about going forward. I've made videos about all aspects of law in Ireland, but I was thinking about doing more in relation to business as well, small business, entrepreneurship, and so on. But I'd be very interested to see or hear your comments down below. Let me know what you think I should be making videos about for my channel.